Hello, I'm Maura Millis, the Interim Executive Director of the Northeast Region of American Friends of the Hebrew University. I am proud to be introducing the second of our Plan Giving webinar series. Today's program, the Inherited IRA, the 10-year rule and the elimination of the stretch, presented by attorney Neal Myerberg. Neal has extensive experience in tax and financial planning strategies with an emphasis on charitable giving techniques. Today, Neal will share his expert advice and strategies for tax-wise giving, things that you may want to consider when reviewing your financial and estate plans. American Friends of the Hebrew University is proud to present this series to our friends that help support your interest in the Hebrew University and raising awareness for the impact in Israel and for people around the world. Hebrew University is Israel's premier institution of higher learning and provides our students with a superlative education while producing world-class research and innovation. The latest Shanghai academic rankings of World University places Hebrew University among the top 5% universities worldwide. Our webinars help develop a community of support for the academic excellence, cutting-edge research, and enterprising innovation that the Hebrew University provides for Israel and globally. Thank you for being a part of our AFHU family. Now I turn the webinar over to you, Neal. Thank you.
Okay, thank you, Maura. Let me share my screen with everybody. Welcome, everybody. I'm glad you're here on a nice, hopefully where you are, summery day. We're going to talk about a topic that is interesting, troublesome, still in the midst of refinement, and something we all ought to pay attention to, and that is this whole idea of what happened as a consequence of what is called, the Secure Act. The Secure Act, which was passed at the end of 2019, taking effect in 2020, was a legislation that began the process of reducing the ability that people had who inherited IRAs from taking their draws during their life expectancy. It imposed this 10-year rule, and the 10-year rule is what we're going to talk about, because while there is a 10-year rule that will probably affect a number of people, maybe the majority of people, there still are exceptions to it that we have to consider when dealing with the issue of an IRA. Now, we wrote this, when this first came out, I created this slide, which in essence says, here's what we saw at that moment. When the Secure Act of 2020 began and how we dealt with it, we simply said, the retirement distributions are going to now be taken within 10 years, can't be stretched, and require tax payment on each distribution over the beneficiary's life expectancy. That was what it was before the stretch. It no longer is. And then I said in this initial document back in 2020, those who want to leave a retirement plan assets to children, let's use the word IRA in our presentation, but it applies to all qualified plans. Those who want to leave it may need to consider alternatives, one of which I'll discuss later on, is the use of a charitable remainder trust, because as many lawyers are doing now and many planners are endorsing, that may be one of the ways to provide for children and grandchildren without requiring them to take these instant and short-term withdrawals, particularly if they're young. So for those who wish to leave retirement plan assets, among other reasons, I'm going to show you as we go on how to use a charitable trust. It may be something that you'd be interested in. So how do we deal with the stretch withdrawal elimination? There are some exceptions, and you can see them right here, exceptions built into the law. The surviving spouse of the original owner can take it during his or her life expectancy, not bound to the 10-year rule. A minor child, not a grandchild, of the owner of the IRA can take it during life expectancy. However, when the child reaches majority, which is 21, the 10-year rule then applies. So let's say the child is 17. The life expectancy tables will apply till 17 till 21, and then 21 begins the 10-year term. So in effect, you have an exception for the minor child until the minor child is no longer a minor child. The third exception is if the beneficiary is less than 10 years younger than the IRA owner. So if the IRA owner is 75 and the beneficiary is 66, then that beneficiary who's less than 10 years younger than the original owner can use the exception rule. And lastly, those who are considered to be disabled or chronically ill under the definition set out in Secure Act and as modified by any regulations coming about will be also, they don't, of course, disabled may not be chronically ill and vice versa. They also are exceptions to the stretch rule. They can also take it during life expectancy. That's the stretch rule elimination in general. Let's talk about beneficiary designations pre-Secure Act, because they're going to change a bit when we talk about them post-Secure Act. Beneficiary used to be defined as any party that inherits an IRA, and any party who inherits an IRA who's named on the beneficiary form or determined to be the beneficiary. That's pretty basic. And the DB, the designated beneficiary, would be an individual. And it was determined as of September 30th of the year following the year of the death of the owner. Non-designated beneficiary, anyone who's not a designated beneficiary, which means anyone who's not a non-individual. This was what the rules had been pre-secure. Also, what the beneficiary options were pre-secure. A DB was determined by designated beneficiary if the person died before the date of the required beneficiary distribution, defined benefit distribution, RBD. They have a 5-year rule or life expectancy. Most people, I'm sure, chose life expectancy. If the death occurred of the individual, the owner, after the RBD, it would again be longer of the decedent's or beneficiary's life expectancy. This is what it was in non-designated beneficiaries. If you weren't a DB, you died before the distributions were to have begun for the owner, you had a 5-year rule. If it was after the RDB, life expectancy. This was all the rules pre-Secure Act. Now let's talk about the Secure Act. Under the Secure Act, the owner reaching age 72 by April 1 of the year that follows the year reaches age 72 must begin to take required distributions. In this case, required beginning distributions must occur April 1 of the year that follows the year the owner of the IRA reached age 72. Now the Secure Act gives different definitions, and this is important to note when you're doing your own planning. The beneficiary is now defined to be any party that inherits an IRA, party named on the beneficiary form, for example. The designated beneficiary would be an individual, not a trust, not any other kind of entity. The EDB, this is a new term, eligible designated beneficiary, the one who would not be bound to the elimination of the stretch would be, as we said before, and this is now in the Act, the surviving spouse, the child of the participant who has not reached age 21, which becomes an EDB at reaching age 21, no longer an EDB at 21. That's when the person then gets into the 10-year rule. But as long as the child is not of majority, the child is not subject to the 10-year rule. A person who's disabled or a person who is deemed to be chronically ill would be an EDB and not be subject to the 10-year rule. And lastly, someone who's none of the above, but is not more than 10 years younger than the participant, would also be an EDB. Anyone who's not an EDB is called a non-designated beneficiary. Non-designated beneficiaries are bound to the 10-year rule. So this is what the Secure Act says now under beneficiary designations. The regulations that are proposed that are going to be dealt with this month, so we're not clear yet, although we believe these are what they're going to be, is for a designated beneficiary, a DB who's not an EDB, the regulations will say that money has to be withdrawn by the end of the 10th calendar year after the IRA owner's death. So if you're a DB, but not an EDB, and you inherit an IRA from the IRA owner, you've got to take out by the end of the 10th calendar year all of the IRA and pay the taxes. Interesting question. Can you wait till the end of the 10th calendar year at the very end and take it all in one sum? Seems to be the case. Is that a good tax plan? Perhaps. Depends upon the EDB or the DB and what the DB's economic conditions are. taking the money out over 10 years, year by year, might soften the income tax cost. Maybe it doesn't. Maybe the income tax cost will be softened by taking it out in larger sums, as long as it's taken out by the end of the 10th calendar year after the IRA owner's death. For the beneficiary of an EDB, somebody who gets an EDB inherited IRA from the EDB has to be taken out by the end of the calendar year, 10th calendar year. For a minor child, has to be taken out by the end of the 10th calendar year after the minor child reaches age 21, exactly what it was that we proposed in the prior screen. And lastly, this comes very rarely, but it might happen. If an EDB is older than the IRA owner, the remaining balance must be taken at the end of the EDB's life expectancy as of the IRA owner's death. So maybe the spouse is older than the IRA owner. So these rules, although not complicated, do create a lot of conversation to try to figure out, are you a DB? Are you an EDB? Are you a minor EDB? Remember, the EDB as a minor can't be a grandchild. Are you a child who is a minor? Does that mean that the parent who died, who was the owner, or the owner in itself was a young person? It's hard to know, but these are just facts to put in our planning when we're doing planning for individuals who are dealing with the question about how to pass their IRAs. One way to plan, and this is something I think is important to spend some time on, is we've had the occasion to work with some trust and estate lawyers on the issue of planning for disabled or chronically ill people. Let's speak for a moment for people under disability. You know, there's a whole body of law that deals with how do you make planning, forgetting IRA for a moment. How do you plan for a disabled adult child? Do you set up a special needs trust and you give discretion to the trustee in order to make payments to or for the benefit of the child during a period of time, but do it in such a way that the child's entitlements are not being disrupted? Do you do it by some use of insurance or annuity products? It depends upon the planning you've done. But what's happening now is, since the 10-year rule will not apply to disabled individuals, and since they qualify for the 10-year rule, trusts are being created now in which the disabled person will be the only current beneficiary of the trust. Beneficiaries can succeed the current beneficiary, but if the disabled person is the sole beneficiary, the only beneficiary of the trust, then that person can be paid and take withdrawals through life expectancy. We're not dealing with a 10-year rule for the disabled because it's an exception to the 10-year rule. Now, if there are beneficiaries that will be paid from that trust at the end of the life of the disabled person, those people who receive any payments from that trust, the trust that received the IRA as its funding, will have to take their distributions within 10 years. So in essence, think about it this way. There's a disabled adult child, and there are adult children who are not disabled. And you create a trust to receive the IRA assets. The IRA assets go into this trust. It's couched as a special needs trust, in order that over the lifetime of this disabled person, there'll be payments made and only being drawn out to the extent of the life expectancy under the discretionary formula, so it can go beyond the 10-year period of time, soften the tax costs, and soften the amount of money that has to be spent every year. After the end of the lifetime of the disabled person, if he or she is survived by other beneficiaries named in the trust, those other beneficiaries will continue to get paid, but their payments from the trust will be based upon the 10-year rule. There may be one of them, there may be several of them, but it will work on that basis. This works well for both disabled people as defined and people who are chronically ill as defined, because it enables them, based upon your planning, to set up a transaction which will be of real protection for the disabled person. With a lawyer in a law firm I've worked with recently on behalf of its client, their client, it was involved an older person. The parents of this 40-year-old disabled person, the parents are both close to 70. And so their issue is, we don't know how long we're going to live. My husband has a IRA, I have an IRA. What we want to do is to be certain that our IRAs go to each other. But we use an IRA trust, which means that if our IRA goes, my IRA, say the wife says, if my IRA goes to my husband, he will be entitled to do withdrawals from that IRA without regard to the 10-year rule because he's a spouse. But the IRA trust will provide at the end of the lifetime of the surviving spouse of the two of them, all the IRAs, both the IRA of the predeceased spouse and the IRA of the spouse that has deceased, which was the recipient of the first IRA, will all go into this trust for their disabled child. Of course, they don't know how old the disabled child will be. They're both in their 70s. They could live to 90. Disabled child then would probably be in his 60s, but nevertheless, still relatively young, depending upon the disability. So what they decided to do was to create these two trusts, an IRA trust, so that the second person of the couple that receives it will be bound within the terms of the trust, no 10-year rule. And then at the end of the second person to die, that trust will be payable for the disabled adult child, measured at that point, assuming the law remains the same, by life expectancy and not by the 10-year rule. So in the planning box at the bottom, what's been suggested is use IRA benefits for a trust for disabled or chronically ill in the form of a special needs trust. You can have multiple beneficiaries as long as the primary initial beneficiary is somebody who qualifies as disabled or chronically ill, and then distribute other assets for other beneficiaries outright or in trust, or they can be beneficiaries of the trust after the lifetime of the disabled adult child. It is always difficult to plan for adult disabled children, of course, for non-adult disabled children. But the issue is, how are we going to protect these children after the end of the lifetimes of the parents? Special needs trust, sure. But let's put it in such a context where the special needs trust that receives an IRA is governed with rules that don't deal with the limitation of the 10 years. So this is an example number one that has been done recently by a law firm with a very high-end trust and estate lawyer, because she, in this case, felt that would be best for their particular clients. The second way of doing this, and again, this depends upon a lot of variables, is to provide at the end of the lifetime of the IRA owner or the IRA owners that the IRA assets be payable to a tax-exempt charitable remainder trust. Charitable remainder trust is governed by IRS rules, by some state laws. It has a great deal of regulation, but if you meet the regulations, you get the results. So the charitable remainder trust may be a tax-exempt annuity trust or uni trust. An annuity trust means a fixed rate payable for the life or lives of the beneficiaries. A uni trust means a fixed rate payable for life or lives of beneficiaries, but every year the amount will adjust based upon the revaluation of the trust, multiplied every year by the fixed rate. So, for example, if the trust is established with $1 million from IRAs, and the rate is set at 7% with an annuity trust, that means the payments will be $70,000 a year for the total term of the trust. If the trust is a uni trust and it's established with $1 million and it's 7%, $70,000 is a payment for the first year. And every year thereafter, at the end of the year, the trust is revalued. Let's say the trust goes from $1 million that began the year 2022 to $1.1 million that entered the year 2023, then becomes 7% of $1.1 million, or $77,000 for the coming year. So then it has an adjustment feature. Of course, it's vulnerable to market, but over the long term, it may keep pace with a normal market, not an extraordinary market that's gone way high or one that's dropped considerably, but a normal market.
Hey, Neal, we have a question.
Yes, of course.
When is the best time to establish a CRT if you need to take distributions within 10 years, immediately or at the end of the 10 years?
Well, since the trust is not going to really function until it's funded, most lawyers are saying, let's just create the trust either in the living trust of the individual or in the will of the individual, and provide in the IRA a designation that is payable to the Mr. and Mrs. Schwartz Trust, and the trust really doesn't exist because it isn't funded to the end of lifetime. That's when the period of time begins to run. And since it's a charitable remainder trust, and since the beneficiaries would not be subject to any of these rules, the 10-year rule doesn't apply. From that point on, it runs for life or lives, not for 10 years.
Okay. And then we have one more question, if you don't mind.
Yes.
So if you don't need the proceeds of an IRA for living and want to pass them on to your kids, is it better to name the kids as beneficiaries or one of the living spouses and then the kids after the second spouse passes?
Well, if it's children and you leave the IRA directly to the children as beneficiaries, which lots of people have been doing, the children will be bound to the 10-year rule, which means if the children, say, are in their 60s, just arbitrarily establishing that, by the time they reach 10 years after that age, that the payments will be done. Most people, when they plan these kinds of transactions, said, my kids will be the beneficiaries and they'll have payments for their entire life expectancy. That won't be the case. These alternatives I'm applying here show that you can get elimination of that problem by doing it this way, but outright, whether you give it to the surviving spouse, and then the surviving spouse gives all the IRAs to the children. If it's going directly to the children, they will then be subject to the 10-year rule, either at the death of the first spouse or the death of the second spouse. That's just what the rules are now. We're trying to find ways, therefore, to get around those rules. And by the way, this screen I'm showing you now is not brand new based upon the 10-year stretch. It's been in use for a long time because of the tax exemption and tax deductions that come about. I'm going to continue, of course, pending your questions. These trusts that I'm talking about here can run for life or lives of individuals, or the longer of life or lives are 20 years. So it has flexibility and can be funded by all or a portion of the IRA. So the IRA designation could say this, for example, it says 50% of my IRA shall go to my charitable remainder trust that has been formed in my will or my living trust, or is already a shell, which the lawyer might decide to create a shell with no funding, and 50% of my IRA will go to my children. So your children would have the benefit from the CRT and also have a benefit from the IRA directly, but they would be subject in the second example to the 10-year rule. We fix a rate in these trusts. The rate can't be less than 5%. Sorry, there are IRS tests that decide what the rate will ultimately be, but it can't be less than 5%. We're hoping that the rate will be higher, and it's just a question of meeting IRS tests. What we're trying to do is to attempt to replace or expand the stretch. And we want to expand the stretch. This will expand the stretch measurably because the payments will go on for life or lives, and lives can be more than one person. Those of you who are familiar with charitable gift annuities know that can only be one or two individuals for life or lives. In a charitable remainder trust, there can be any number of individuals as long as it meets the test of the rate. Because I've said in this bullet point here, to the extent it can have a qualifying rate, at least 5%, it could make payments for grandchildren. This trust could run for a considerable period of time, making payments at the stated rate for children and for grandchildren. But I want to represent to you that if grandchildren are quite young, that may be the trust, because it will be presumed to be running a great deal of time once it begins, might not be able to make this rate. You may have to limit the amount of time it runs to be certain you include the grandchildren, but meet the rate at the end of the term of the trust. And this is mathematics. This is what your trust and estate planner, your CPA should be looking at, is at the end of the term of the charitable remainder trust, after payments have been made to all the named beneficiaries, either those in being or those in a class in being. You can name grandchildren who haven't yet been born as part of the class in being. The charities receive the remainder interest. So, for example, you could provide at the end of the trust that at the end of the trust, whatever remains in it goes to American Friends of the Hebrew University to establish a scholarship fund, an endowment fund, something that would be memorable for your children and grandchildren to see that's been done with this kind of legacy that you've left as a result of your plan. You see on the bottom, though, and I've added this to you because some people were will always question, well, if I create a charitable remainder trust, even though I'm making benefits because I'm, in this case, avoiding the 10-year limitation, providing for all my children and maybe grandchildren at a fixed rate for life, sometimes an adjustable fixed rate in the unit trust, yet there's no value to this trust for my estate or my heirs at the end of the lifetimes of all these people. Well, of course, all these people are essentially your heirs. But if that's the case, some people do what I point out at the bottom. They use wealth replacement planning. So, for example, maybe your children are beneficiaries before your grandchildren here, and your children say, we're going to take some of the benefits we're getting annually from this trust, and we're going to pay the premiums on a life insurance policy for the benefit of our children, your grandchildren, that will be payable to them at the end of certain periods of time, maybe end of lifetimes, using maybe an irrevocable life insurance trust, so we don't have to pay gift or state taxes. We can expand it that way. This is, in essence, something that creates a solution to the problem of the 10-year rule for the people you most want to provide for from your IRAs, from your qualified plans. Who are those people? Of course, spouses to each other, but more significantly, the next generation. How are you going to provide for the next generation under the current rules when you know that no matter what, they have to spend it, receive it, pay tax on it within 10 years, and then it's done? And all your planning before this change in rules were, it would not be done. It would run through life expectancy. That's not going to happen under current rules. One could always argue, well, maybe it'll change in 10 years from now. Well, yes, but this is pretty strongly codified. And this is what the government wants, because it wants to get its taxes from IRAs quicker than it was originally intended. Remember, to go back in our history, IRAs were funded with pre-tax dollars. IRAs grew tax deferred. IRAs weren't taxed until the owner reached now age 72. IRAs get taxed at age 72 for this person based upon the owner's life expectancy. Owner dies, passes it on to next generation. IRS did not want to continue to let it be stretched past that time and said, now, 10 years. If it's 10 years, we're going to get all our taxes out because we didn't expect you to believe we weren't going to get our taxes back, and we'll get them back at ordinary income tax rates. For the prior screen, trust for disabled adults, special scenario. This screen, trust for children, grandchildren, much more relevant to many more families. Let me just tell you, I've covered two examples. One, the trust for disabled individuals, and then the family with two adult children using a charitable remainder trust. In this case, they used a charitable remainder annuity trust. They didn't want to have any change in the payments every year. The first IRA of the first participants inherited by the surviving spouse. When the surviving spouse dies, that IRA and the other IRA go into the charitable remainder trust for, in this case, their two children. They weren't inclined to deal with grandchildren, just with their two children, thinking that their two children's payments will be higher and they can provide for their children, their grandchildren as a result. This screen is just for you to have. And by the way, you're welcome to ask for and receive this PowerPoint. It's available to you. This screen sort of in 6 boxes sort of summarizes all that we've just talked about. And it's been a half an hour of a mini webinar, is what we promised. And of course, you're going to have questions. If you read this outline again, or if you if the recording, this has been recorded, you can order the recording. Anything will allow you to learn a lot more about this. This is maybe for some of you an initial conversation about the travails of the absence of the stretch going on. Plan Giving at AFHU is a website to direct your questions. They will get to me and I will get to you. You can ask these questions quickly or over time, and go speak to your lawyers, your accountants, your estate planners about this, because they're grappling with it well, and they're just getting caught up with this and enjoying it. So happy to help. Mara, unless there's any other questions.
Yes, we have one more question, Neal, actually, before we turn it over to Maura.
Okay.
For a charitable remainder trust, is any part of the payments tax deductible, like a CGA?
You mean tax-free, not tax deductible, I think tax-free. Well, like with a CGA, good question. With a CGA, we know that some portion of each annual payment will be tax-free based upon a calculation done at the beginning. And so we know that, and that's based upon the IRS discount rate. With a charitable remainder trust CRT, we don't know that. So what happens is each year the trust issues a Form K1. Those of you who ever invested in partnerships and things like that get a K1. The K1 will say, in my example, 7% of, say, $1 million, that the beneficiaries receive $70,000 and taxed as follows. And it may be, some of it may be ordinary, some may be capital gain, some may be tax-free income. It will deal with that each year based upon the trust's investment performance. So it's different than a CGA where we know exactly how much it's going to be, but it has other results, other uses, and you will get your K1 and it'll try to be tax sensitive. A good manager of a charitable remainder trust tries to make the annual payments tax sensitive. Complicated, I get complicated, but it's manageable and most accountants understand this completely.
Thank you so much, Neal. You always take on complicated issues and help explain them for our American friends in a way that is understandable, and I'm sure that over time we'll continue to send questions and inquiries your way. It's always a pleasure to have you share your financial and tax planning strategies. I want to thank all of our guests who are here with us today for joining us for this webinar, and especially I want to thank members of our Einstein Visionary Society. It's a group of our very special donors who have created a personal legacy at the Hebrew University by making a planned gift. And those members are invited to special events throughout the year, and we have a special recognition both in this country and in Israel. If any of our guests today on the webinar or others that you know are interested in learning more about the Einstein Visionary Society and making a tax-wise life income gift, such as a charitable gift annuity, a bequest, or even, of course, questions about creating a charitable remainder trust that, as Neal discussed today, please reach out to your executive director in your region or contact us at the national office, and we'd be glad to follow up and provide more information. And of course, please let us know if you have already included American Friends of the Hebrew University in your estate plans. Thank you again, and we very much hope that you'll join us for future webinars, and we look forward to being in touch. Bye-bye.